So the rhetoric of indigeneity, that is, there's a need to decolonize the Indian legal system, that is, to get back to some kind of Indian roots, to in a sense, make it more accessible was there. But think of the analogy that I will give now. Think about education. So, as we know, education in India is not accessible to large numbers, has not been for decades in its history. So imagine that the diagnosis of inaccessibility of education is not because of poverty or lack of resources of the government or basically supply side problems, but instead you say that it is because education in India is a Western form. We should have Indian kind of education. We should indigenize it. We should make it simpler. We should teach people, sewing and tailoring and, non-formal education, as they call it. So that is the kind of thing that happened with the rise of informalism from the 70s. That is, instead of trying to make the legal system accessible by pulling down barriers, instead you try to change the legal system itself by saying that it's not suited to Indian conditions. Imagine if you say that education is not suited to Indian conditions. For some. Remember that the legal system was to be changed in this manner for the people who it was inaccessible to. For the Ambanis and for the rich, it was supposed to say the same. So think about the analogy of education again. So people like me, coming from a upper class background, they would continue to have the regular education. But for the poor, you'll have non-formal education. बच्चों को सिलाई कढ़ाई सिखाओगे. Because that idea that you will adapt it supposedly to Indian realities is obviously a troubling one to me, at least. So that's what happened in the Indian law. Instead of providing legal aid so that people can access the same institutions, but with the aid that can be provided through through state provisions, you do not act. So the attempt to address this inaccessibility was not done through legal aid, but rather through informalism. And this informalism was introduced, in almost all areas, in terms of in almost all branches of the legal system. So it would happen at lok adalats, so-called lok adalats were introduced at the lowest level. The tribunalization, the introduction of tribunals for every area of law now that you have in India, also gathered a pace from 1976 with the 42nd Amendment, and finally PIL at the highest level, High Courts and Supreme Courts. So the idea was that, that a large area of litigation would get diverted to these parallel forms, which would be more accessible. And that's what has happened. And in fact, the idea of judicial reform and legal reform in India has been dominated by this trend towards informalism for the last 4 decades. And that continues to be the solution for a lot of people, despite the fact that obviously by now it should be obvious to any observer that it has been a spectacular failure. Anyhow, so for returning to our discussion on PIL, we have to locate PIL within this formula, within this idea of what Galanter and Krishnan have called debased informalism. Right? So it's important that we are conscious of this rhetoric of indigeneity. So from 67 itself, 1967, the Golaknath movement, the critiques of the Indian legal system that came from the executive and from the legislature were twofold. One was that of this kind of a socialistic anti-elitism, and the second was an indigenous rhetoric-based anti-elitism, right? So So, um, so we have to understand that there's been a gradual move from this kind of socialistic rhetoric of elite of anti-elitism to a kind of rhetoric of indigeneity, of foreignness, of the Indian legal system. And that's a troubling one. In fact, the ongoing attempts to reform criminal procedure code, Indian penal code, that has been led by the Indian Home Ministry right now, still ongoing, has been partly actuated by the similar kinds of ideas. Now, as we can see, as we know, when PIL is defined by relaxation of local standard, that's not the only thing. From the beginning of PIL, it's been accompanied by a rhetoric, like I said, of indigeneity, which is also of anti-proceduralism. The idea particularly articulated by Justice Bhagwati, who's perhaps the most influential PIL judge, probably any judge of any kind in Indian history, he would keep using this line: procedure is but a handmaid of justice and not its mistress. The idea being that procedure should not be, we should not be sticklers for procedure when it comes to law. And therefore, many departures were made, not just in initiating litigation, but also in the processing of litigation. So one landmark case, one of the great landmark cases of PIL, Pandwa Mukti Morcha, which pertained to allegations of bonded labor in mines near Faridabad, in Haryana, near Delhi. There were allegations of that kind, which the state, of course, denied, as it usually does. So the court, instead of relying on the affidavits and trying to figure out what was going on, it actually appointed a socio-legal commission, a bunch of people to go and examine the situation there. The Haryana government tried to say that, we can't just rely on these guys, on such evidence without any cross-examination, etc. But the court brushed it aside, saying that in PIL we can't be such sticklers for standard evidence. Now you may say fair enough, but the court need not have gone through need not have introduced such a broad exemption, which, as we will see, has devastating consequences later. It could have, for instance, appointed court commissioners, this mechanism which exists in a civil procedure, which allows the court to appoint an entity to collect evidence, which has processes of checks and balance within it. But the court decided not to do that and instead went ahead and introduced a commission and gave it kind of broad exemption from evidentiary rules, which, as we will discuss, has been a disaster. Another important move in the 80s, there's this very interesting case called Sheila Barsay. This woman from Bombay, a journalist who was agitating a case regarding the condition of juvenile justice homes of the time, which used to be called juvenile homes in those times. And this case, as very often happens, would get listed from time to time and then not heard and adjourned. So after making many such trips from Bombay to Delhi, she was a bit exasperated and she told the court that she wants to withdraw the case because she can't just continue like this. The court was outraged by her suggestion and said that you can't withdraw the case to the petitioner. The case actually belongs to the court, meaning that in a PIL case, they said the petitioner is not the primary litigant, and the case in essence belongs to the court. So they went ahead and removed Sheila Barsay from the case. Now, this is a very interesting development because what does this mean? It basically treats the petitioner as an informant. rather than as a complainant. What is the difference? This terms informant and complainant I'm using from criminal procedure. So suppose I see a crime happen on the streets of Delhi, and I report it to the police station and file an FIR, let's say. The police will treat me as an informant, but I have no special stake in it. I have seen some crime happen on the road. I just bring something to their notice, and after that they go on investigating in the way they think uh, deserves to be investigated, and I have no control over the proceedings. On the other hand, if I'm a complainant, well, if I file a criminal complaint, I have to be made a part of the process in a much more robust manner. What Srila Barsit did was it made me, as the petitioner, as merely an informant and not a complainant, who could be removed from the case. And as we'll see, the petitioner increasingly becomes vestigial to the PIL. So, we see trends already from 1980s of, of more and more relaxation of or diminishing of procedural standards. And the consequences, as we'll soon see, are devastating.